Yes, a very good evening to all of you. Hi Kavya, hi Mukul. Good evening. Hi Kirtana, good evening. Good evening everyone. Welcome to the second lecture for CA Inter Law Revision. Hi Ananya, good evening. Good evening everyone. Okay, so yesterday we discussed. Hi Prathamesh, Yusuf, welcome. Yesterday we discussed indemnity and guarantee. Hi Nishkam, good evening. So yesterday we discussed contract of indemnity and guarantee. Today let us discuss the contract of bailment. Hello Rohit, good evening. Few students had messaged me regarding the chart book. So I'll just share the link again. You can visit my website theorymasterslearning.com and purchase the chart book. We are revising it. We are revising the portion. Yes, we are revising the syllabus with the help of chart book. These are all colorful charts which will help you to remember the concept easily. And these are all head points which you need to remember for exam. Okay, so everything is given to you in chart and colorful format. For the compiler, it is a compilation of all past exam questions, study material, RTP, MTV questions arranged unit wise with full length answers as expected by ICAI. Oh, that's great, Mukul. That's great. 65 बहुत अच्छा है वो तो in CA Foundation. Very good. Excellent. Okay. So let us discuss bailment. I think today's session will be a very small session because bailment and pledge it's a very small unit. And after we discuss the provisions, we are also going to discuss three important questions which I have highlighted from my compiler. Those are very frequently asked concepts in the exam. So we are going to discuss questions. The format of the questions is the one which you had followed in foundation. First, you will write the provisions followed by facts of the case, analysis, and then conclusion. Okay. Let us discuss bailment. Now, how many questions will be asked from bailment and pledge? As I informed you yesterday, students, this revision is going to be totally exam oriented. I will be discussing with you not only the concept but also the type of questions that are asked, what is the weightage of the chapter, which are the important sections on which questions are frequently asked. So it is going to be a totally exam based, exam oriented revision. From the contract of bailment, you can expect just one question. Is a question asked from pledge? Is it compulsory? No, it is not compulsory. Yes, you may be asked a multiple choice question, but it is not compulsory that they will ask you a theory question or a case based question from pledge. It is just a matter of chance. So you can expect just one question of maybe 4 marks that will be asked from bailment. Okay. So definition of bailment, yes, do we need to memorize it? Generally, definitions are to be memorized. In case of indemnity and guarantee, I had mentioned that learning the definition is not important over there because very rarely a question is asked on essentials of guarantee. But here, essentials of bailment is a frequently asked theory question. Okay, so this is a frequently asked theory question. That is why if you are asked to write the essential elements, you will first have to write the definition. That is why it is important for you to memorize the definition along with the section number. But it is okay if your definition is not word to word the same. If it is 80% similar to the definition given in the act, it is fine. You need not worry about that. Now, what is bailment? But before we discuss the definition, let me give you a small example discussing the concept of bailment. So let me clear the page for you. Okay, so what is bailment? Now let's say for example that X is a dealer in stationery. He purchased many notebooks to be sold in the month of June and July. That is when the colleges and schools reopen. So he is the owner of a stationery shop. Okay, he's the owner of a stationery shop. He purchased many notebooks but he didn't have place to keep all those notebooks in his go down. So he approached his friend Y and he told Y, will you keep these books in your go down? It's just a matter of 2 months. After 2 months, whatever is not sold, I will take it back. Y agreed. He said, Arey, you are my best friend. How can I refuse you? So X delivered the notebooks to Y. This act of delivery is known as bailment. So bailment means to deliver. Okay, bailment means to deliver. The person who delivers the goods is known as the bailor, and the person to whom the goods are delivered is known as the bailee. Yes, tell me, does the bailee become the owner of the goods? In case X delivers goods to Y, has Y become the owner? Is Y the owner? Hi Satvik, good evening. No, Kavya, correct answer. Bailee is not the owner. He acts just like a caretaker. Who is the owner in this case? It is the bailor. So bailor remains the owner. After the purpose is over or after the expiry of the time period, he will receive back the goods. Whatever expenses are incurred by Y in taking care of the goods that can be claimed from the true owner X. X is the owner, he will bear the loss, owner will bear the risk. So in this case, bailor X will remain the owner. Now let us talk about consideration. Consideration is not required to create a valid contract of bailment. Why is consideration not required? Law says that the benefit which, law says that there is no requirement of consideration. Bailment can be a valid contract even without consideration. It's one of the exceptions to the rule no consideration, no contract. So what is the consideration for X? We need something. So for our understanding, we will say that let's say X asks Y, how much money will you take? Y says, Arey, you are my best friend, तेरे से थोड़ी ना पैसे लूंगा. So Y allows X to keep the goods in his go down free of cost. But we need some consideration for our understanding. So the benefit received by X, okay, now X, what is the consideration for X? Y is going to keep the goods safely. He is going to return the goods after the purpose is over. That is enough consideration for X. Consideration for Y. X has trusted me. He has parted with the goods. That is enough consideration for Y. So in this case, there may not be actual consideration or movement of money. But the fact that Y has parted with the goods is enough. Sorry, X has parted with the goods. That's enough consideration for Y. And consideration for X is that Y is going to take care of the goods and return the goods after the purpose is over. So that is a contract of bailment. Okay, so we discussed all the essential elements. Now let us discuss the definition followed by the essentials. Section 148, yes, the section number is important. You need to memorize section 148. What is bailment? Bailment is delivery of goods. Okay, so these are the elements which I am highlighting from the definition itself. The delivery of goods by one person to another for some purpose. So there has to be some purpose which is generally temporary. Like say for example, caretaking of the goods. Upon a contract, it means all the essential elements of a valid contract must be present. When the purpose is accomplished, the goods shall be returned or otherwise disposed of according to the directions, instructions of the party delivering them. So these are the 5 essential elements of bailment which we highlighted from the definition itself. So what is bailment? It is nothing but delivery of goods. Delivery means there is voluntary transfer of possession from one person to another. Acha, now tell me, in this case, X delivered the goods to Y. He voluntarily gave the goods to Y. We are delivering goods. Goods means every kind of movable property. So goods are the subject matter of bailment. You cannot bail immovable goods because you cannot deliver the immovable property. So goods means every kind of movable property. From one person to another, it means from the bailor to the bailee. Upon a contract, it means all the essential elements of a valid contract should be present. We need two parties, proper offer, acceptance, enforceability, free consent. And the goods shall be returned after the purpose is over. That is the basis of bailment. Or they may be disposed of according to the direction or instructions of the party delivering them. It means they may be delivered according to directions of the bailor. Now let's discuss with example. After the purpose is over, Y will return back the goods. Yes, Y will return back the goods after the purpose is over. X delivered goods to a carrier. Okay, he delivered goods to a carrier for the purpose of delivering to Z, the buyer. Now the carrier is acting just like a bailee. The purpose of this bailment is to deliver the goods to the buyer. Here the goods will not be returned back to the bailor, but they will be disposed of. It means they will be given to the buyer as per the instructions of the bailor. So this is also bailment. So what are the essentials of bailment? There is always a contract. Okay. It is always based on a contract. It means all the essential elements of a valid contract have to be present. Consideration is not necessary in case of contract of bailment. Bailment is an exception. It is valid even without consideration. But that doesn't mean that there need not be consideration at all. Let's take another example over here. X gave a watch to Y for repairing. Y is going to charge him 100 rupees. Here there is consideration for the parties. It is bailment. But if X has allowed Y to keep the notebooks in his godown free of cost, that is also bailment. So bailment does not require consideration. Okay. In this example, Satvik, I think you joined late. The person who delivers the goods is known as the bailor, and the person to whom the goods is delivered is known as the bailee. So here X is delivering the watch, X is the bailor, and Y is the bailee. In my previous example, I forgot which example I had taken, just it came out impromptu. Okay. So here it is bailment. It involves delivery of goods from one person to another, and that delivery is generally for some temporary purpose. Please note that in bailment, I am not transferring ownership. I am only voluntarily transferring the possession. So over here, it involves delivery of goods. It means there is voluntary. Okay, what is delivery? It is nothing but voluntary transfer of possession. There is voluntary transfer of possession. Okay. Hi Munindra. You purchased my lectures for CA Foundation, na? Yes. Maza aa gaya. Oh, thank you so much. Okay. So it involves delivery. Yes, I will ask questions, Sambhav, but let me at least explain, because there are few students who are giving me attempt or other attempts. So let me first explain, then of course I will ask you questions, because even I enjoy the question answer session more. Yes. So Munindra, thank you for your feedback. Really appreciate. So there is voluntary transfer of possession from one person to another. It is generally for temporary purpose. I am not transferring ownership. I am only transferring the possession. Bailment is only for movable goods, never for immovable goods or money. Now, why is bailment only for... Yes, Munindra, I remember. Your name is very unique. That is why. Okay. So bailment is only for movable goods, because only movable goods ka possession can be transferred. It is never for immovable goods, because you cannot transfer possession, you cannot deliver immovable goods. No, Sambhav, I have prepared a timetable, and in 10 days we are going to complete the entire syllabus, so don't worry about it. If you want, we can go faster, but that should be acceptable to all. Okay. Same goods must be returned in the original form or in the desired form. Okay, so here let's say for example X has delivered notebooks to Y. We want notebooks to be delivered, not loose sheets of paper. X delivered a X delivered a gold necklace to Y. So we want that necklace should be delivered, or you can change the form, you can change it into a new design and deliver it. Okay. So you can deliver it in the original form or the desired form as required by the Bailor. There is change of both custody as well as possession and not ownership. There is change of custody as well as possession. Now, what is the meaning of custody? Custody means to hold, and possession means you have the right. Okay, so custody means to hold, and possession means you have the right. Now, in this case, let's say that X asked his servant to deliver few utensils to Y. Now, servant is going with the utensils. So X asked his servant to deliver the utensils to Y. So X is going with the utensils. He is holding the utensils. He has the custody. But does he have the right to use the utensils as he like? No, he doesn't have possession. Servant is not the bailee. But yes, as soon as he delivers the utensils to Y, Y will not only have the custody of the utensils, but also the right to use those utensils as per the instructions of the Bailor. Once the custody as well as the possession is given to Y, then it is a contract of bailment. Hi Vicky, how are you? Students, please note that change of both custody and possession is important for case based questions. इस पे case based questions ज़्यादा आते हैं. And you just have to remember that custody is you are holding the goods, whereas possession, it means you have the right to use those goods. Both have to be transferred to create a valid contract of bailment. Okay, now parties we discussed, essential elements we discussed. Next, let us discuss the duties and rights of Bailor and bailee. This is a very interesting part because duties of Bailor are rights of bailee. Where is it? Yes. So duties of Bailor, they are rights of bailee, and rights of Bailor are duties of bailee. So it's very interesting because एक की duties दूसरे की rights हो जाते हैं. Now, what are the duties of Bailor? What kind of question will be asked? Mostly on all this, case-based questions will be asked. Okay. Now, it is the duty of the Bailor to disclose the faults in the goods. Here they have classified the bailment into gratuitous and non-gratuitous bailment. Gratuitous bailment का क्या मतलब होता है? Yes, what is the meaning of gratuitous bailment? Can you tell me? What is the meaning of gratuitous bailment? What is gratuitous bailment? Gratuitous bailment means free of cost, free of charge, and non-gratuitous bailment means we expect something in return. Now, in this case, if it is a gratuitous bailment, let's say, for example, that X gave a horse to Y. Okay, X gave a horse to Y without charging anything in return. Now, in this case, X is bound to disclose only the defects which he is aware of. Yes, only those defects which he is aware of. What if the horse turns violent, or there is, let's say, a scooter? That will be better. Let's say that X gave a scooter to Y. So X is bound to disclose only those defects that he is aware of. Okay, only those defects that he is aware of. In case of gratuitous bailment, the bailor is liable only for the defects that he is aware of. एक तो वो free में दे रहा है, so he will be liable only for the defects that he is aware of. लेकिन अगर वो non gratuitous bailment, that means he is charging some money. Okay, he is charging let's say 1,000 rupees for the scooter. अगर वो कुछ पैसे दे रहा है, then he is liable for all the defects whether known to him or not. क्योंकि वो पैसा ले रहा है, so he will be liable for all kinds of defects. Duty to bear the loss. See, bailor is the owner. Owner bears the loss. Owner bears the risk. Duty to bear expenses. Now, X delivered notebooks to Y. Y built shelves to keep the notebooks safe. जो भी expenses Y incur करता है, that is to keep the notebook safe. He is incurring on behalf of the bailor. In case of gratuitous bailment, the bailor will be liable for all expenses, ordinary as well as extraordinary expenses. Now, what are ordinary expenses and what are extraordinary expenses? Let's say that X bailed a dog to Y. Okay, X bailed a dog to Y. Now, Y is not charging anything. वो free में उसका ध्यान रखता है. X is bound to give Y ordinary as well as extraordinary expenses. Now, what are ordinary expenses? Ordinary expenses are those which we are incurring to take care of the dog. भाई अभी dog है तो खाएगा ही ना, तो उसके जो ordinary expenses है वो bailor देगा, because bailor is the owner, he will bear the expenses. Extraordinary expenses, अरे the dog fell ill, then in that case those expenses will also be borne by X because he is the owner. It is a gratuitous bailment. एक तो Y free में तुम्हारा काम कर रहा है. But what about non-gratuitous bailment? What if Y is charging 1,000 rupees to take care of the dog? Then in this case, X will be liable. That is, bailor is liable only for the extraordinary expenses. Why? देखो, अगर Y ने 1,000 rupees कोट किया है तो उसने कुछ ना कुछ तो सोच समझ के ही किया होगा ना, कि डॉग का ख्याल रखना है, dog will eat. So ordinary expenses are borne by the bailor, whereas ordinary expenses are borne by the bailee, whereas extraordinary expenses are borne by the bailor. Bailment gratuitous हो या non gratuitous हो, expenses are always borne, extraordinary expenses are always borne by the bailor. Duty to indemnify the bailee in case of loss due to premature termination of gratuitous bailment, section 159. Now, X, he delivered a horse carriage to Y free of cost. Gratuitous bailment है ये, free of cost. Okay, X delivered a horse carriage to Y free of cost. Now Y hired a horse ये सोच के कि मैं horse carriage चलाऊंगा, vacation time है, kids को लेकर जाऊंगा, I will make good profit. The horse carriage was bailed for 5 days, but after 3 days X cancelled the bailment. He says, I want my horse carriage back. Now in this case, because it is a gratuitous bailment, we are giving you the right to terminate the contract even before the expiry, even before those 5 days are over. But Y had hired a horse for 5 days ना, उसने तो 5 दिन का horse लिया हुआ है, 3 days ही सिर्फ carriage चलाने मिला. So whatever loss he has incurred for those 2 days can be recovered from the bailor. Duty to receive back the goods. Bailor is the owner. It is his duty to receive back the goods after the bailment is over. Achha, now I'll ask you a question. Answer this. Bailor had bailed a horse to the bailee. ठीक है? Bailor had bailed a horse to the bailee for 5 days. After 5 days, bailee came to return the horse. Bailor said, नहीं नहीं अभी मत आ, come after 2 days. So bailee took back the horse and kept it for 2 days. The horse consumed food. So bailor spent 100 rupees as feeding expenses. So tell me, can the bailee recover those feeding expenses from the bailor? That is my question. Can he recover those 100 rupees per day as feeding expenses? Yes, of course, if the bailor refuses to take back the goods, the bailee has incurred expenses, he can recover it from the bailor. Duty to indemnify the bailee for the loss caused due to defective title of the bailor. If we find that the bailor is not the owner and he bailed the goods to the bailee, whatever losses suffered by the bailee can be recovered from the bailor. Okay, so bailor is responsible for defect in title. Then we have rights of the bailor. It is the bailor's right to claim damages in case of negligence of the bailee. This is a very simple point actually. I don't think I need to explain it. Bailor is the owner. Ideally, bailor bears the loss because he is the owner. But he can recover the damages which he has suffered due to negligence of the bailee. Right to terminate the contract in case of unauthorized use. X bailed a horse to Y for his own riding. But Y started using the horse for commercial purpose. Bailor, you can terminate the contract because it is against the terms of the contract. Now, what if due to this unauthorized use, bailor suffered loss? Then under section 154, he can claim compensation. So let's say, for example, X bailed a horse to Y. Y started using the horse for commercial purpose. Because of overriding, the horse died or the horse was injured. Now this loss is suffered by X, the owner of the horse, due to unauthorized use by Y. X will first terminate the contract under section 153 and then he will claim compensation. Right to claim separation or damages in case of mixing of the goods. Actually, 3 sections are involved over here. Section 155, 156 and 157. What is in 155? Do you know what kind of mixing takes place in section 155? Can you tell me? What kind of mixing takes place in 155? Do you remember the provisions of section 155? What happens in 155? Yes, correct. Here there is mixing with the consent of bailor. Okay, with the consent of bailor. It happens with the consent of bailor. And 156 and 157, here the mixing happens without the consent of bailor. Okay, now if let's say that I allowed the bailee to mix my goods with his own goods, whatever is a mixture that remains after fulfilling the contract, we can share that mixture because everything is happening with the consent of bailor. But what if the mixing is without the consent of bailor? See, if the goods can be separated, then the bailee will get the goods separated and return the goods to the bailor. But what if the goods cannot be separated? Then bailee will compensate the bailor because of this unauthorized mixing of goods. Okay. Then we have right to demand the return of goods after the purpose is over or after the expiry of the term. See, bailor is the owner. He has the right to demand the goods from the bailee after the purpose is over. Right to claim compensation in case of unauthorized retention of goods. Time is over. But even then, the bailee is not returning the goods. Let's say that bailor bailed an umbrella to bailee to be used during the exam period. He bailed the umbrella for 7 days. Now, bailee was coming to return the umbrella after 7 days. Let me reframe the example. X bailed an umbrella to Y to be used during exam season and he gave it for 7 days. But Y retained it for 10 days. Now, after 10 days, he is coming to return it. Y fell and the umbrella broke. The bailor can claim the loss from Y due to this unauthorized retention. Right to demand accretion. Accretion means addition. So X bailed a cow to Y. Now cow gave birth to the calf. Y is supposed to return not only the cow but also the calf. Okay. Now, duties of bailee, they are very similar to rights of bailor. We need not cover everything again. It is the duty of the bailee to take care of the goods like a man of ordinary prudence. And if some extra care is required by the contract of bailment, then you need to take extra care. Thank you so much, Suyog. Okay, it is the duty of bailee not to make unauthorized use. Otherwise, he will have to pay compensation. So if we gave the horse and he started using it for commercial purpose, we can terminate the contract and claim the damages from the bailee. Duty not to mix the goods with his own goods, section 155, mixing with the consent of bailor. See, the chart book is so comprehensive that if you study only the chart book, you will be able to revise the entire concept. No, Satvik, agar 7 days में loss होता, then the bailor will bear the loss if it is not due to the negligence of the bailee. Acha, 156 is mixing without the consent of bailor, but the goods can be separated. So we will ask the bailee to give us the goods after separation. 157 mixing without the consent of bailor, but the goods cannot be separated. In that case, bailor बोलेगा भाई separate नहीं हो रहा मेरे को, तू compensation दे दे. So he can claim compensation. This is important for case-based questions. Okay, students, important for case-based questions. Duty to return the goods after the purpose is over. If we fail to return the goods after the purpose or after the expiry, then we will be liable to the bailor for loss. So time period is over, we have to return. If we don't, we will have to bear the loss. Duty to return accretion, duty not to do anything inconsistent. Acha, bailee cannot sell the goods. Bailee cannot start using the goods. Bailee cannot pledge the goods. He is not the owner. He should not do anything inconsistent with bailment. He is only a caretaker. He has to take care of the goods. Okay, so that was the rights. Lian, yes, this is very important for exam. Lian, the last concept of bailment, and we will complete bailment. So even by going slightly slow and covering everything, in half an hour's time, we completed the entire concept of bailment. Okay, so chart book revision, the chart book is the best way to revise because everything you will cover, and that also in record time. Satvik, if the goods are perishable, then in that case, again, the bailor will be responsible because he is the owner. Bailee will be liable only if the loss is due to the fault of the bailee. Okay, let us discuss lian. This is important for case-based questions. इस पे बहुत recently question आया था. We are going to discuss that. Now, what is the difference between particular lian and general lian? Lian means to retain. Now, bailor has bailed goods to the bailee. Bailee has done some work on those goods, like he has exercised his skill, he has put labor, he has added value to the goods. Okay, he has increased the value of the goods. Bailee can retain the goods till he is paid for his services. If the bailee is not paid, Naveen, the class is from 7 to 8. 7 to 8. So in this case, the bailee, if he has exercised skill, labor, he has increased value addition kiya hai, then he can retain the goods till he is paid for his services. Now, particular lian means lian which can be exercised only if the bailee has by his skill or labor improves the goods, he has added value to those goods. He can retain for non-payment of remuneration. Now, let's say for example that bailor gave a rough diamond to Y to polish it, cut it. तो Y ने उसको polishing किया, cutting किया, उसका value increase कर दिया. If he is not paid for his services, he can retain the goods. मैंने उसको leather दिया shoes बनाने के लिए. उसने shoes बनाया, labor डाला, skill डाला, shoes बना के दिया. उसने shoes बना कर दिए. अब जब तक X उसको payment नहीं कर देता, Y can retain the shoes. But this particular lian can be exercised only if he has put some labor, उसने value addition किया. If he simply takes care of the goods, तो particular lian apply नहीं करता. But what if bailee को तो उसके lian के right के बारे में पता ही नहीं था. He delivers the goods to the bailor without getting paid for his remuneration. Don't worry. If you have given back the goods to the bailor, yes, lian is lost because you are no longer in possession. But you can very well file a case against the bailor and recover the money. Case तो कर ही सकते हो. General lien. Now this lien can be exercised by bankers, factors, wharfingers, attorneys, only by certain persons by default. But it can be exercised by others also subject to an agreement. Acha, now what is the meaning of general lien? Bankers के पास already general lien होता ही है. It means let's say the bank gave a loan of 50,000 rupees to X on security of gold. Then he again gave 20,000 on the security of this gold only. Now X repaid the first loan, but the bank can continue to retain the gold until the entire amount of 70,000 is paid, because he has general lien, he has a lien on the entire balance of account. तो जब तक पूरे पैसे नहीं मिल जाते, बैंकर ये गोल्ड अपने पास रख सकता है. He has general lien, जो भी उसके पास आया वो सब रख लेगा until the entire amount is repaid. So students, with this we complete bailment. Pledge is also a kind of bailment. Okay, pledge is a kind of bailment. But pledge में the goods are bailed for loan given as security. Okay, so my purpose is to give something as security. To give security for debt or satisfaction of the contract. Now let's say for example that X gave her jewelry as security to Y. Now in this case, we are delivering the jewelry. It is bailment only, but what is the purpose? We are giving it as security. This is nothing but pledge. You are giving something as security. So bailment to apply karega hi, but the essentials of pledge will also apply. The person who delivers the goods is known as the pledger or the pawner, and the person to whom the goods are pledged is known as pledgee or pawnee. Okay. What are the essentials of bailment? Pledge. Pledge is a kind of bailment, but we have given goods for security. Goods are the subject matter for pledge because yes, it is a bailment. Bailment is possible only for movable property, that is goods. Pledge is for existing goods only. You cannot pledge future goods. Delivery is essential for pledge because pledge means transfer of possession. You have to transfer the possession. Okay. Rights of pawnee, pawner, this is not very important. For example, I'll only discuss the parts which are important. This is important for case-based questions. Right to retain towards subsequent advances. Now, let's say that X gave his watch, gold watch, okay, he gave his gold watch as security to Y. He obtained loan of 5,000. Then he again obtained a loan of 1,000 rupees. So if there is an agreement, then Y can apply this watch to subsequent advances also. So this section 174 is very important for case-based question, that if there is a contract, then it will also apply to subsequent advances. All right, students. So इस पे case-based question आता है, and generally it's a very simple question. But yes, you need to memorize this for exam. तो अगर आपके पास स्टडी मटेरियल है तो इसको प्लीज हाईलाइट कर लो. So ideally, pawnee is not entitled to retain the goods for the debt other than what was promised. But if the pawnee lends money to the debtor after the date of pledge without any further security, it shall be assumed that the right of retainer extends even to some subsequent advances, unless it is otherwise provided in the contract. मतलब कि अगर उसने बोला है कि नहीं specifically mention किया है कि ये is goods, ये subsequent advances को apply नहीं करेगा, then in that case it will not apply. So over here, X gave a gold watch to Y. He obtained a loan of 5,000. Then he again borrowed 1,000 rupees. So the gold watch can be applied even to the subsequent advances. So this is important. Otherwise, बाकी तो मुझे नहीं लगता इतना important है. Okay. Pledge by non-owner, yes, it is very important. It can be asked as a theory question. So please इसको highlight कर लो. Can be asked as a theory question. But this is very similar to sale by non-owner, if you remember. Sale by non-owner. So in case of sale, हम pledge word use कर देंगे by mercantile agent. Okay. सो मर्केंटाइल एजेंट प्लेज्ड गुड विद एक्स, उसके पास अथॉरिटी नहीं थी, या फिर उसके पास अथॉरिटी टू प्लेज फॉर 5 lakhs बट ही प्लेज फॉर 6 lakh rupees. Pledge is valid provided X takes it in good faith without knowing that mercantile agent does not have any authority to pledge. He was in the possession. तो there are certain conditions, इसमें मुझे नहीं लगता कुछ explain करना है, because it is very similar to sale by non-owner. अच्छा, pledge by person in possession under a voidable contract, इस पे बहुत important case based questions आते हैं. And please remember the example that I am discussing it with you, वही example आएगा exam में. Now X by fraud obtained a necklace from Y. Okay, X by fraud obtained a necklace from Y. Now we know that fraud hai, that is why the contract is voidable. It means that Y can either treat the contract as valid or he can cancel the contract. But before Y could cancel the contract, X pledged, okay, he pledged the necklace with Z. Now Z took it in good faith without knowing about the voidable contract, without knowing that X is not the owner, he doesn't have the authority to pledge. उसने तो fraud करके लिया है. Law says that if certain conditions are satisfied, then even though X is not the owner, pledge will be valid. इसका मतलब है कि Z को जब तक अपने पैसे नहीं मिल जाते, he will not return the necklace. Pledge by co-owner is valid under certain circumstances. Pledge by seller or buyer in possession after sale and where the pawner has limited interest. Okay, बाकी तो सब repeat है. This is a new point, so I'll explain it with example. X found a watch lying on the road. Okay, he found a watch lying on the road. He got it repaired by spending 100 rupees. And then he gave it to Y as pledge and obtained a loan of 300 rupees. Later, Z, the true owner, came to know about this. उसको लगा अरे मेरी वॉच कहाँ पर गई. He went to Y and he told Y कि अरे ये जो वॉच तेरे पास प्लेज हुई है ना वो मेरी वॉच है. Y said ठीक है, I'll give you the watch under one condition, that you will have to pay me whatever is your interest in the pledge. Now what will Z say? I had lost a defective watch and I found a repaired watch. मैं भी रिपेयर करने जाता ना तो 100 rupees में स्पेंड करता ही था. So X का Z का interest is 100 rupees, that is the cost of repairs. तो Z will pay 100 rupees to Y and he will take the watch. Now Y will tell X कि अरे तेरा interest तो 200 rupees है ना. 300 rupees was the amount of loan, 100 rupees you spent on repairs, so 200 is your interest. So X, you pay me 200 rupees. So Y will recover 100 rupees from Z and 200 rupees from X, जिसका जितना interest वो पैसा दे दो और watch recover कर लो. सात्विक, आई थिंक यू आर आस्किंग अबाउट द वॉइडेबल कॉन्ट्रैक्ट. सो व्हाट विल हैपन कि जेड को जब तक अपने पैसे नहीं मिल जाते प्लेज के, वो नेकलेस नहीं देगा. तो वाई एक्स को बोलेगा कि तू उसका लोन रीपे कर और मुझे वो मेरा नेकलेस ला कर दे. इन शॉर्ट वी आर ट्राइंग टू प्रोटेक्ट द राइट्स ऑफ जेड. जब तक उसको अपना पैसा नहीं मिल जाता वो नेकलेस रिटर्न नहीं करेगा. एंड ओवर हियर ऐसा भी हो सकता है दैट वाई विल पे द मनी टू जेड. जेड को अपने पैसे मिल गए, नेकलेस वो ले लेगा और बाद में जाके वो एक्स के अगेंस्ट केस करके उससे वो पैसा और डैमेजेस रिकवर कर लेगा. So here we are not trying to discuss from all the parties' point of view. We are only trying to discuss from the point of view of the pledgee. We are just trying to protect the interest of the third person. Students, इसी के साथ हमारा pledge भी खत्म हो गया. मैंने important जो है exam point of view से वो discuss कर लिए. I would like to discuss the questions with you now. Okay, questions discuss कर लेते हैं. मैंने 3 questions identify किए हैं मेरे कंपाइलर में से. सो यू कैन परचेज द कंपाइलर फ्रॉम माई वेबसाइट theorymasterslearning.com. इट हैज़ ऑल द पास्ट एग्जाम स्टडी मटीरियल, RTP, MTP क्वेश्चन सब यूनिट वाइज दिया हुआ है. टुडे आई हैव आइडेंटिफाइड क्वेश्चन 5, क्वेश्चन 9 एंड 7.1. आई वॉन्ट यू टू आंसर नाउ. ओके, चलो क्वेश्चन 5 रीड कर लेते हैं. This question has been asked 3 times. That is why I am discussing it. उसकी weightage देखो कितनी ज़्यादा है. 3 बार इस पे questions आए हैं. Amar bailed 50 kg of high quality sugar to Shrijit. So Amar is bailing, he is the bailer. And he is bailing to Shrijit. Shrijit is the bailee. Promising to give 200 rupees at the time of taking back the goods bailed. ठीक है. Shrijit's employee, unaware of this, mixed 50 kg of sugar. Okay, there is mixing. Immediately मेरे माइंड में कौन से सेक्शंस आ जाने चाहिए? टेल मी, मिक्सिंग से रिलेटेड कौन से सेक्शंस है? 3 सेक्शंस मैंने आपको बताए थे. मिक्सिंग से रिलेटेड 3 सेक्शंस थे. विच वर दोस 3 सेक्शंस? Can you answer? What are the 3 sections involved? Mixing से related we have section 155, 156 and 157. So here he is unaware. Baylor is unaware. Yes, very good Prathamesh. Kirthana 155, 156, 157. Here the Baylor is unaware of the mixing. So which section should apply if, let us read, this came to light when Amar came by asking for sugar. What is the remedy available? Can we separate the sugar mixed here? Can we separate the sugar? Which section will apply? Yes, correct answer. 155, 156, 157 relates to mixing. But which section should we apply over here? 156, 157, 155. Which section should we apply? We should apply section 157 because here mixing of goods cannot be separated. Yes, goods cannot be separated. 157 will apply. So what will happen? What is the remedy available in this case? Yes, 157. Goods are mixed. They cannot be separated. Yes, goods cannot be separated in this case. So what will happen? What will the Bailor say? Bailor क्या बोलेगा? Can he ask for the goods to be returned? No. But can he claim compensation? Yes. So what will we write? We will write the section number in the first paragraph. ठीक है, section number हम लिखेंगे. Mixing of goods takes place without the consent of the Bailor. If he mixes the goods, bailee will pay damages to the Bailor. Very good, correct answer. So here it is not possible to separate. We can recover damages. So yes, we can recover compensation. Then I have identified question 7.1. Let's see if you can identify. Srishti acquired a valuable diamond. Okay, S acquired a diamond under a contract voidable. The voidable contract was not rescinded, it was not cancelled. Srishti then pledged the diamond with VK. Is the pledge valid? I just discussed with you. Is the pledge valid? सेक्शन नंबर क्या है voidable का? सेक्शन नंबर 178A, voidable. Is the pledge valid in this case? Is the pledge valid? Yes, the pledge is valid. Pledge is valid because the pledge is happening before the main contract is cancelled. Main contract valid रह गया तो उसका collateral जो pledge वाला contract है वो भी valid हो जाएगा. So pledge is valid. So you just have to write that the pledge is valid and explain section 178A. The next question which I identified is an extremely not tricky, but it's a very unique question. Okay, Shobit, I'll just share the WhatsApp link. You can, I think, find it in the description of this video. I'll just see. Yeah, I'll share it with you. Shobit, you'll have to click the bell icon. Only then you'll get notification. Otherwise, every day we are meeting at 7. Radheshyam borrowed money from the bank on security of gold. Under an agreement which contains a clause that bank will have particular lian. Generally banks have general lian. यहाँ पर वो बोल रहे हैं कि उसको particular lian होगा. ठीक है. Radheshyam took an unsecured loan of 20,000 from the bank. He repaid the entire he repaid the entire second loan of 50,000. Requested bank to release the gold pledged with him. तो राधेश्याम ने 50,000 लिया था अगेंस्ट गोल्ड ऑन 1st जुलाई 2019. Thereafter, on 1st August 2019, उसने एक और अनसिक्योर्ड लोन ले लिया 20,000 का. 50,000 तो उसने रीपे कर दिया. बट कैन द बैंक कंटिन्यू टू रिटेन द गोल्ड टिल द सेकेंड अमाउंट इज रीपेड? क्या लगता है आपको? Generally, banks have general lian. Shobit, the link was shared. Today I shared the link. You may have joined late, I think. Just click the bell, you'll get the notification. Okay. Yes, I hope others you are replying. Generally banks have a general lian, लेकिन यहाँ पर हमने बोला है bank has particular lian. It means he can retain the gold only for the first loan. नहीं, generally उनको general lian रहता है. Even though it is unsecured, they can continue. सात्विक, वो continue कर सकते हैं to retain the gold. There was an express contract for particular lian. नहीं, it's particular lian. The bank can retain only for 50,000, not for 20,000. And if particular lian was not specified, then yes, he can retain till the entire amount of 70,000 is paid. So students, with this we complete the chapter on bailment and pledge, और हमने 3 questions भी discuss कर लिए. Tomorrow I will start and finish agency, और उसके बाद हमारा contract act खत्म हो जाएगा. Then we will discuss negotiable instruments act in just 1 lecture. पूरा act 1 lecture में कर लेंगे. General clauses and interpretation again in 1 lecture itself. So this is how we are going to discuss, and 8-10 दिन में हमारा पूरा syllabus अच्छे से revise करके हो जाएगा. For fast track lectures, please visit my website theorymasterslearning.com. I'll share the link again for those students who joined late. This is my website. You can purchase the chart book, compiler, as well as the fast track lectures from my website. Tomorrow we are going to discuss contract of agency. 1 घंटे में पूरा with question answers discuss कर लेंगे. Okay, so I'll see you tomorrow guys. Good night. Study well, पढ़ते रहो, and कोई भी difficulty होगी तो please feel free to contact me. My number is given on the website. कोई भी doubt होगा you can contact me. Yes, company law also we will revise. We will do it fast करेंगे, जो important है वही करेंगे exam के लिए, but we will try to finish everything quickly. ठीक है? प्रथमेश, एनीवेज कोई डिलीवरी चार्जेस तो है नहीं, और अगर आप मुंबई में ही हो तो आज अगर आपने ऑर्डर किया तो नेक्स्ट डे डिलीवरी है हमारी, तो आपको उतना ट्रैवल नहीं करना पड़ेगा. इफ़ यू वांट यू कैन परचेज इट, नो प्रॉब्लम. So just contact me on my WhatsApp number, and I'll give you a time. You can come at that time and take the books. You can take it physically also. But we have 1 day delivery in Thane, so no problem. आप time मत waste करो. मेरा वही अभी 1.5 महीना है exam के लिए. So don't waste time in traveling. Otherwise choice is yours. I don't mind. अगर आप आ भी जाओगे तो बहुत अच्छा है. ठीक है students? चलो. So, bye everyone. Bye bye. I'll see you tomorrow at 7 o'clock.